Hi and welcome to this latest immigration law update video. In this video, I'm going to look at a new case from the Court of Appeal, which was handed down remotely during the coronavirus lockdown, on Article 8 and families with children. I've looked at this before in some previous videos, and this obviously covers EX1A, 276ADE4 and Section 117B6 of the 2002 Act, and obviously covers the question of the reasonableness of children leaving the UK. And we're talking here of 7-year children or British children. Just for the citation for you, the case is Runa, and it's 2020 EWCA Civ 514, and it was handed down on the 8th of April 2020. This is a decision of Lord Justice Singh, and he overturns the decision of Deputy Upper Tribunal Judge Mandalia and remits this case to the first tier tribunal, but on the way gives some important guidance on the operation of the reasonableness question, particularly focusing on Section 117B6 of the 2002 Act in this case. The background facts are the appellant, Mrs. Runa, is a Bangladeshi national. She entered the United Kingdom in 2006 as a visitor and overstayed. In 2014, she married a British citizen and made an application for leave to remain on the basis of being a partner. In 2015, she had her first British son. After that, her appeal came before the first tier tribunal, who allowed her appeal. The respondent Secretary of State applied for permission to appeal to the upper tribunal. In 2018, her second British son was born. When her case came before the upper tribunal in 2019, the upper tribunal judge found an error of law in the decision of the first tier tribunal for failing to make proper findings and erring it in its approach to 276 ADE, and then went on to dismiss the underlying appeal of the appellant. So the appellants then appealed to the Court of Appeal from the decision of the upper tribunal, and there were two grounds, and that was the Deputy Upper Tribunal judge had erred in his construction and application of the reasonableness test under Section 117B6, and also that he'd erred in his application of the proportionality assessment under Article 8 outside of the rules. In terms of Section 117B6, I'm sure a lot of people watching this video will be aware, but it says this: in the case of a person who's not liable for deportation, so this doesn't apply in deport cases, the public interest does not require the person's removal. So we know that it's a freestanding provision, it's a standalone provision, where A, the person has a genuine and subsisting parental relationship with a qualifying child. So a genuine and subsisting parental relationship have to look at all the facts and look at the nature of the relationship. Qualifying child are British children and 7-year children. In this case, it's obviously British children. And B, it would not be reasonable to expect the child to leave the United Kingdom. And it's that little b, the reasonableness test, that was the focus of the Court of Appeal in this case. Now, the Deputy Upper Tribunal judge appeared to examine two scenarios. One, that the children would remain in the UK with their father, and two, that the entire family unit would relocate to Bangladesh. In terms of that second issue about relocating to Bangladesh, he'd said, well, there were no insurmountable obstacles to the husband following the wife. And if there were no insurmountable obstacles, it normally would be reasonable for the children to follow. He also appears to have contemplated that it would be reasonable for the children to remain in the United Kingdom with their father alone. And that's paragraphs 21 and 22 of the Court of Appeal judgment. So at the heart of this appeal, Lord Justice Singh says, is the correct interpretation of Section 117B6, paragraph 23. And of course, the leading cases on this are KO Nigeria from the Supreme Court, where the Supreme Court said the question of reasonableness focuses on the child alone. And the Court of Appeal case of AB Jamaica, in which Lord Justice Singh also gave judgment, where the Secretary of State had tried to argue that where the child wouldn't go, the question of reasonableness doesn't arise, and that was rejected by the Court of Appeal. Now, you'll see from paragraph 24 that in this case, the appellant tried to argue, well, where one of the parents has a right to remain, for example, as in this case, the one parent is British, splitting up the family would be against the best interests and therefore it would not be reasonable. Effectively, the appeal should just be allowed if one of the parents has a right to remain in the United Kingdom. That was rejected by the Court of Appeal. But the Court of Appeal did accept the alternative submission, paragraph 36, that in one of these cases, a fact-finding exercise must be undertaken in order to establish all the background facts and answer the lone question of whether it would be reasonable for the child to leave the United Kingdom. That's the sole focus, and it's a child-centered focus, as we were told in KO Nigeria. One other thing to note is actually this is a benevolent provision, paragraph 32. So where you meet 117B6 and it wouldn't be reasonable, your appeal should succeed. Where you don't meet 117B6, a tribunal should still go on then to conduct a freestanding Article 8 assessment outside of the rules. In this case, the upper tribunal was found to be in error because it erred in its approach and just answered the wrong question. It looked at these two alternatives about whether the whole family should go or the children should remain, rather than answer the central question to 117B6. And the question is not whether there would be insurmountable obstacles to the family living there, paragraph 37. And in fact, they emphasise that even in terms of a normal Article 8 case outside the rules, GM Sri Lanka reminded us that the question is not insurmountable obstacles. That is the test under EX1B, but is only a relevant factor when it comes to a wider proportionality assessment. So at paragraph 42 in this case, they found that the upper tribunal judge's approach was fundamentally wrong in this case. Now, because there hadn't been proper findings of fact, the case was remitted all the way back to the first tier tribunal so that question could be answered whether it would be reasonable adopting a child-centered approach for the child to leave the United Kingdom. And obviously in the alternative then there's the wider proportionality assessment outside the rules. So a helpful case worth looking at. I hope you're well and safe and this is helpful.